She obtained her Bachelor of Laws degree from University of Technology Mara and was admitted as an advocate and solicitor of the High Court of Malaya in 2008. Ms. Farah has experience in a wide range of commercial litigation, including companies or corporate disputes involving shareholders and directors, winding up disputes, contractual disputes, and tortious claims. Whilst her area of special interest is defamation, as well as public and administrative law, Ms. Farah also regularly renders advice and act for both local and international clients in matters involving land and tenancy disputes, probate and administrative disputes, and various debt recovery and insolvency matters. Ms. Farah has appeared as co-counsel and counsel at all tiers of the Malaysian courts and played a key role in many noteworthy cases in Malaysia, which are reported in the law journals. Apart from the court appearances, Ms. Farah also has been involved in commercial arbitration under the Arbitration Act and mediation under conciliation mediation rules of the AIIC. Without further ado, Ms. Farah, please take the stage.
You take over the camera. Okay, thank you so much, Amelia, for the introduction. Hi, everyone. So sorry to keep you waiting. Unfortunately, I was delayed in court. I will get to the lesson that we learned today in court as to what happened in the later part of my webinar. So my team has actually put together a Prezi slides that I will share with you throughout this webinar. Maybe we can try and see if those slides will work and if you can see it. Nadia, maybe you can start sharing the screen. Okay, all right. I hope everyone can see the screen. If anyone has issues viewing the shared screen, please let us know. Like what Amelia said, just put a chat in the chat box, and we will try to resolve the issues for you. Otherwise, I don't see anyone putting up their hands, so I'm going to proceed and assume that everyone can actually see what I'm seeing on my screen at this moment. So, litigation 101. What really is litigation? Let's go to the first slide. I have a disclaimer to make, and that all the graphics or background pictures that you see throughout this presentation are not my personal choice. It's obviously my team's preference, from the lawyers and whatever you see later. So I do not associate myself with any of these images, although I do love suits, as a matter of fact. Okay, so what is litigation? Definition of litigation, the formal definition of litigation is basically the act, process, or practice of settling a dispute in the court of law. So that is the official or common or formal definition of what amounts to litigation. So when you say that I'm doing litigation, or you talk about litigation, it is actually a very wide area of law. So what is it that, what does litigation entail really? Can we move to the next slide, Nadia? Let's look at the various practice areas about litigation. Now, first we look at the types. Now, for those of you who are not in practice, I note that some of you are already in practice, some are partners in their own firms, some are in-house counsel, and some are pupils, just joining our firm or current pupils in other firms. So basically, when you first think about being a litigator, the first question that you must ask yourself is, okay, do I want to be a criminal lawyer or a criminal litigator or civil litigator? Of course, in ZRp, we don't really do criminal matters. So today's talk, I'm going to focus more on the civil aspect of litigation. But these are, at the very outset, the two aspects or the two branches of litigation at the very top. So we have criminal and then you have civil. And under civil litigation, there are actually many more practice areas. So some of the lists are actually listed out here, and this list is non-exhaustive. There are many more areas of law, new areas of law that has emerged recently. Okay, from this list you can see if you're a litigator, you can be a banking litigator, you can focus and practice on financing, clinical negligence law, commercial law, competition law, construction, corporate, so criminal is also there. Dispute resolution actually covers all that as well. Employment, environmental, family, human rights, intellectual property, international law, environmental law, maritime, media property, public, sports, tax, and tort. Now, some of you may ask, why is it that some parts of it are actually highlighted? Those parts that are highlighted are actually comprises of the practice area that we actually practice here in Rafique. I'm actually hearing some sounds. Okay, I'm not imagining it. Okay, sorry about that. Yeah, so those highlighted parts are in fact the areas of practice that we, the broad areas of practice that we do here in Rafique and Partners. However, of course, under those broad area of practice, there are further specialization that we actually do practice in ZRp. And some of the, as I mentioned, there's emerging areas of law, like we now have digital law, tech law. These are all new areas which are not in the list, which is also why I've stated here that this area is actually non-exhaustive, but I think it gives a general idea to all of us on the wide area of laws that you can actually explore if you were to actually practice practice or as a litigation lawyer. Of course, if you go to if you're practicing in a big firm, the area of practice are usually more specialized. If you have most big firms have their own specific intellectual property department or banking department, construction law department, just like how we here in ZRp, we have specific dispute resolution or litigation department. We have a specialized construction law department. We also have a specialized and dedicated employment or industrial relations department that specifically deals with all employment related issues. Some of the smaller or medium outfit may do a mix of any of these areas and practice all the areas across the board. So it really depends on which firm you're in, or which whether you are actually specializing in a specific area or you are actually a general litigation practitioner, so to speak, dabbling into all these various areas of law available. Nadia, can we move on to the next slide? Okay, so basically, what does a job as a litigation lawyer entail? So a lot of people ask me all the time, what do you do as a litigation lawyer? Because when you mention the word litigation or litigator, they automatically attribute that to, oh, you must go to court. You're before the court, you speak, you present your case, and you fight before the judge and, at a trial. So a lot of people actually associate litigation with the act of actually conducting a hearing or full trial before the court. But actually, that is not the only thing that litigators do. We do all other, there are many steps that actually leads to that trial that you see on TV. That is, of course, the glorified part of being a litigator is all about. However, actually, before we get to actually appear before the court for a hearing or for a trial, a lot of effort and preliminary work has to be put in place to actually ensure that our case can actually proceed smoothly. So here we have just to give you an idea of what kind of work that we usually do. So preliminary work for litigators usually entails information gathering, strategizing, rendering preliminary opinion, issuing letters of demand, or issuing reply to a letter of demand. So many times when we are engaged by clients comes to us with a specific problem. So litigators, we're usually looking at the act of resolving the dispute for the client. So when the clients are stuck in a particular transaction or stuck in a particular situation and they want to know how to get out of it, whether amicably or going to court. So you'll be surprised. So not all clients actually come to us because they want to go to court. It's like most of clients just comes to us because they are stuck in a specific situation or in a predicament and they don't know how to get out of it. Maybe if they have to go to court, maybe not. Most clients would actually prefer not to go to court as far as possible. for obvious reasons, like going to court might be scary for some people. Some people do not really look forward to sitting in the witness box for days, being under cross-examination of counsel, and the length of time, from the moment you file the action to the suit actually being disposed of, that might take some time. So actually, as litigators, we come on board from the very outset of the matter. Some more sophisticated and experienced entities would even come to us before the problem actually triggers. The fight, so to speak, has not really taken place, but they already anticipate, based on the events that take place or the exchange that take place between the parties, they already foresee that there's potentially going to be some problem, but sometimes we issue a letter, the other side starts responding to a letter and become very contentious. So companies that have either their own legal department or companies also who are aware about all these things will already know, look, this is already potentially litigious. So at that point of time, at the very outset, at that juncture, they would usually start engaging litigation lawyers and start asking for our advice. Look, we are in the midst of having all this exchange with the counterparty. From the tone of their letter, there seems to be a problem. It might lead to court, it might not lead to court. Can you help us? Can you have a look at this and see that in the event it goes to court, we are secured in our position, that we have not stated anything in our letters that will prejudice our case later on when we go to court. So as litigation lawyers, we actually do all this kind of advisory work where we look into the matters and we look at the exchange of letters and look at it, yes. And then sometimes when we have sight of these letters, we can even tell that, yes, when they say certain things in these letters, that is already a precursor to litigation. It's actually adopted from another decided case, and they're hinting about what position they're going to take in the event the matter actually proceeds to trial. So all these are actually preliminary work that we will usually do. We will, when the client comes to us, we will gather the information. We'll ask them what are the relevant facts. Sometimes you have wonderful clients who will come to you with a beautifully bound documents, chronologically, all nicely tabulated, makes your life a lot easier to look at all the documents. Sometimes the clients come to you and they just say they have a problem. They don't know how or where to start. They don't even know what information to actually give to you. So as a litigation lawyer, you then need to exercise or practice your skill of actually eliciting all this necessary information from them. So even at that juncture, even though you're not in court, you're somewhat doing cross-examination or examination in chief of your client. You have to ask them, so what is the problem? So who is the counterparty? What is this contract? Or show me the contract. Okay, this contract refers to this document. This contract has this clause. Was this clause done? Did you do this? Did you do that? So at that juncture even, from the very outset, as litigators, you have to be able to have the grasp and to have the basic knowledge. If you're referring to a commercial transaction, if your clients are companies or corporation, you must have this background knowledge or commercial knowledge to know that, okay, if you're talking about a breach of contract, then obviously the first thing that you want to ask is, can I have a look at the contract? But if clients come to you and say, I have a problem, my next door neighbor, the land had a landslide, something escaped into my land, now I've suffered loss and damage. Now what does that say? That hints, if all of you here today are at one point studied law or went to law school, then all these things would actually give you a hint that the kind of problem they have is actually tortious in nature. So if it's a tortious case, usually what we do is we will have to conduct a site visit because we actually have to see the place. If they're saying that it's a landslide, it's an escape, it's a tort of nuisance, we want to go say, okay, first thing we say is, okay, can we schedule a site visit? So we can go on site and really see what's going on, where did the land escape from, or water or whatever, underground and things like that. So these are the kind of basic information that litigation lawyers ought to have at the very outset of the matter. So from the moment the client comes to you, you have to be able to either know or at least ask all these right questions in order to elicit the right information that will then help you to strategize your case and way forward. So once you have asked all these questions, once you are in possession of all the relevant documents, you have cited the documents, you have conducted your site visit, then you can tell the client, okay, so strategizing and preliminary opinion will usually come together. Then you can tell the client, okay, I've looked at your papers, I've looked at this, so this is what we do, or this is perhaps what we can do. So as litigators, we usually do not tell client unless it's a very clear-cut, say, breach, perhaps what they have done or what they want to do is clearly in contravention of the contract or is clearly in contravention of a specific act. We don't really usually tell client, look, you don't want to do this, you don't want to do this, you should do this. You know what? Instead, we tell the client is that, okay, this is your problem. These are the options that are available to you. Okay, and this option will probably land you to court, most definitely, but you have a good chance of succeeding in court. Second option, you may not go to court yet, but it might take longer because you're going to then have to go have back and forth negotiations and things like that. Third option, you go to court immediately, but you might incur costs and things like that. So you give all these options to the client, and ultimately we can make recommendation, but usually we will leave it to the client to make the ultimate decision as to what, which course of action that they feel would is something that resonates with whatever it is that they want to do, and is consistent with their commercial, with whatever commercial decision that they want to make in due course. Although I must say that there are instances where we have clients, more often than not, would tell us no, who come to us and say, no, you tell me, what should I do? So under that case, we'll say, okay, yes, you have option A, B, and C, but perhaps option A would be the best course of action because it is the option with less resistance, or it is the option that would give you better prospect of success, and so on and so forth. So that's what we do. And then depending on the nature of the advice sought by the client and the stage at which you're on, at the point of time when the client actually instructs you or gets you on board on the matter, you will either then have to prepare a letter of demand to be issued to the counterparty, stating your client's position and demanding certain things that your client wants to demand from the other party. Or sometimes the client might already come to you and say, look, Farah, I've received this letter of demand from the other side. They want me to respond within 14 days. What do we do? So under those circumstances, then we won't be issuing a letter of demand. We may be issuing a reply to that letter of demand instead. And in that reply to a letter of demand, depending on the circumstances, we ourselves may have some counter demands to make to the other parties. So these are the usual preliminary work that we do at the outset or before a matter actually proceeds to full-on litigation. And aside from all this, as I mentioned, there are also instances where clients come to us just for advisory. So no dispute, no nothing, but they just want to know, okay, we are negotiating this contract. There is this clause, but we want to know what could possibly happen in this clause. What are the worst case scenario if it goes to court and we are caught under this clause? You know? So under those circumstances, we will just be rendering opinions and advice on the clients, and with no real or immediate necessity for the matter to escalate further to court. Now we can move on to the next slide. So, okay, so this stated here main suit. So this is basically, I think what it's referring here is to when matters does actually proceed to litigation or to a full-on dispute. So if you have issued a letter of demand or replied to a letter of demand, usually what would happen is that, sometimes there will be further exchange, at least 1 or 2 rounds of exchange of letters. I say I want this, the other side will reply, say no, I don't want to give you that, but can you take this instead, back and forth. And sometimes parties can actually settle the matter at that point without actually escalating the matter further. But there are times when all those exchange of letters does not lead you to any amicable settlement, or even by issuing one letter of demand, no response whatsoever, complete silence on the other side. So what do? You don't just wait indefinitely for people to reply, to your demands. So the next step would usually, depending on the circumstances, is to proceed either with litigation by filing a claim in court, or to proceed to arbitration if you have a contract and that contract stipulates that you have to go for arbitration. So the list that is stated here under the main suit here: pleadings, interlocutory applications, pre-trial, trial, submissions, and execution. This actually applies for both litigation as well as arbitration. Of course, the actual how it happens in arbitration and court are a bit different, but the process is actually about the same. So the main suit, when you talk about litigation, taking the first step, what is it that you do? After demand, you file pleadings. If you are a plaintiff, you will start with filing a statement of claim, a written statement of claim against the other side before the court. If you are the defendant, you're not involved with the written statement of claim, you will instead be served with a statement of claim. And once that's done, you will then have to file your appearance as well as defense. I will get in more detail on this later. And once, so pleadings involve filing of statement of claim. Usually it's 3 rounds. So first is written statement of claim, and then you have defense or defense and counterclaim, and then you have reply or reply and defense to counterclaim. So normally it's just these 3 rounds. It does not really extend further, but under some circumstances you will have extra pleadings, a reply to defense to counterclaim. So under those circumstances, you will then need to ask for leave from court to actually file the subsequent pleadings. Then you have here interlocutory applications. Now, some of you already in practice will already know what are interlocutory applications, but for the benefit of those who are not in practice or not in practice yet, who have not heard of interlocutory applications. So interlocutory applications are basically a subset of the main suit. So when you file a suit before the court, you have your claim or a counterclaim in the main suit. And then sometimes in that claim, you have other smaller things that you need to deal with before full trial. For instance, you want to go for trial, you have filed a claim, you want to go for trial, but you don't have some documents, but you know that the other side has have these documents in their possession. So you file an application for discovery to ask the other side to produce these documents. That is an interlocutory application. Sometimes you've already filed a writ or a claim or a defense, and then once the pleadings are closed, you realize, oh dear, you forgot to plead certain things, some factual matters that are very, very important. So you now find yourself in a position where you need to amend your claim or amend your defense. So under those circumstances, you need to file an amendment application. That is also a type of interlocutory applications. Interlocutory application also refers to injunctions. So we have injunctions, amendments, discovery. I think the list goes on. Okay. So then normally what the court does is that once you file a claim, the court these days, because they want to dispose of suits as early as possible, they will tell both parties, as far as possible, file your interlocutory applications by the next case management. So if I, for instance, if I were to file my suit in January, the very first case management before the court would likely be at the end of January or in the first month of February. So then you come to court for the first case management, and usually what will happen is the court will tell you, look, before the next case management, file any interlocutory applications that you want to file. Yes, I actually missed out the 2 most important and common interlocutory applications that are usually filed at the very outset, which is a summary judgment application as well as a striking out application. So these 2 applications are usually filed at the very outset of the case. Summary judgment is where you have a claim and you are and the defendant does not really have a good defense or meritorious defense against the case. So rather than going for full trial and waste time and cost for trial, you file a summary judgment application so that that case can be disposed of within the first 2 or 3 months of you filing the claim. Or it could be the reason where you are a defendant, you have been cited and included as a defendant in the case, but then you realize, hey, I'm not supposed to be a defendant. This is wrong. I'm not even a party. This is a contractual dispute. I'm not even a party to the dispute. So I want to file a striking out application. So these days, all these applications will usually have to be filed at the very outset or as early as possible after pleadings filed in the main suit has already closed. So once all the interlocutory applications have been disposed of, assuming you don't get summary judgment or a summary judgment is not entered against you, because if a summary judgment is entered against you, then technically that's the end of the story for that time, at that time in the High Court, unless the counterparty actually files an appeal to the Court of Appeal. Or if you file a striking out application and you succeed on your striking out application and the application is struck out, then that will be the end of the suit for that time until or unless you actually file an appeal to the Court of Appeal. So if that happens, then that will be the end of your suit at the High Court for now. But assuming that the other side filed summary judgment, but they were not successful, or you tried to striking out, court says, no, I don't want to strike out, you have to go for full trial. So that's when you have to start doing your pre-trial preparation, and then you go for case management, and the judge will hand down what is called pre-trial case management directions. So what are pre-trial case management directions? Usually the judge will say, okay, I will fix the trial. Let's say, so you are now, you filed the action in January, this is best case scenario. Sometimes it doesn't proceed as fast as that. You file your suit in January, you have your case management in February, you dispose of all your interlocutory by March. By March, you know that you have to proceed for full trial. The judge will then fix the matter for full trial. Normally, if your CM is by March, if it's a High Court, you're looking at a trial by end of the year, perhaps second quarter or third quarter, depending on the court schedule. If the court is, if the judge has free dates, then you might get your trial dates earlier. I just fixed, my LA just came back from court yesterday, where we basically got trial dates in January 2023, because the trial for that particular matter is before a judge who is involved in some other very high-profile criminal cases. So he's literally fully booked in 2021, he's fully booked in 2022. So our trial is actually fixed in 2023. So what then happens, we're now in April 2021, trial is in January 2023. Does it mean we don't do anything between now and then? That's not the case. Okay, a lot of things has to be done between now and January 2023. It's just that depending on your trial dates, that process will just have to, either you can take a little bit more time preparing for that process, for your trial or that process, or you actually have to rush or step on the pedal and make sure that you meet all the deadlines imposed by the court. So now we go to pre-trial preparation. So the court will usually ask you, okay, you need to file your bundle of pleadings. Not difficult, because it literally means you just compile the claim, defense, and reply that you have filed into a bundle. Court will say file bundle of documents. Now this can be quite challenging because this will entail you filing whatever documents that you think are relevant for your client, and then the other side will then produce their documents, and then you have to look at each document, and we have to go through this process where to expedite and to facilitate trial these days, the courts will usually ask parties to categorize documents. They will say, okay, we need to categorize these documents into Part A, Part B, and Part C. Most clients or some in-house counsel or clients who do not have in-house counsel will ask us, what is this Part A and what is this Part B and what is this Part C? That could be overwhelming for them as well. So we will tell them, okay, Part A is where the authenticity of the documents are not in dispute. If you are talking about a certificate or a license issued by the government, unless you say that it's fraud and that license was not issued. So most likely those kind of documents will be in Part A. Part B is where the authenticity of the documents are not in dispute, but the veracity of the documents or the contents of the documents is subject to proof. For instance, you have a contractual dispute and you're fighting on a contract. Now, you're not disputing that you signed a contract. I signed the contract, other side can sign the contract. Contract is not disputed. What we are disputing is the clauses in that contract and how it applies against or for us under the circumstances. So that will be in part B. Part C is where I look at the document and I don't even know who issued it. I have no way of actually ascertaining the veracity of the documents. And the document is such that I would want to cross-examine and to ask the maker of this document on the nature of it. You know, like perhaps it's a letter written by an individual to your client or to the other counterparty. Now, you would want to look at the letter and say, no, I want to call this person because this letter says this, you know, to clarify and to cross-examine that person whether or not this is what he meant by the letter. So under those circumstances, those documents will be in Part C. And then we have pre-trial preparation will also usually entail you preparing witness statements. Now, I think a lot of people, when they talk about trial or litigation, you know, we associate that a lot with dramas, you know, TV dramas or movies, where you see a witness basically sitting in a witness box and most of the time having the day at the time of the day in telling their own story. You know, I was there on such and such a date. Sorry. And you know, this happened, I wasn't called and things like that, you know, telling the court their side of the story. But in effect, in real life, or at least in Malaysia, what happens is to save time and to save costs, rather than spending half a day just listening to one person, you know, setting out their story or their version of what actually transpired on the day in question and things like that. So one step back, so that process of a witness coming to court, explaining on his or her version of the story and giving his evidence at the very outset is called examination in chief. So to cut time and cost, examination in chief in Malaysian courts these days are usually conducted by way of witness statements. So these days, lawyers will usually prepare witness statements. So witness statements will be like a Q&A. State your name, where were you on such and such a date, what did you do, why did you do that? And witness statements, because they are to be adopted as your examination in chief, the normal rules of examination in chief would apply, meaning you should not be asking leading questions in your witness statements. You cannot ask in your witness statements, on that day, were you in that building? Or, you know, or questions that would lead the witness to certain questions. Was it blue or was it red? You can't ask leading questions in your witness statements. Instead, you have to ask, where were you on such and such a date? Can you tell us where you were? What were you doing? So it's all open-ended questions, so that the witness is then, even though it's in writing, it's in the form of a statement, the witness can still put in his or her own version of what actually transpired. In reality, what usually happens is that the lawyers will prepare the witness statements, and the clients will then have to confirm and agree on the witness statements. Now, I usually make it a fact I actually usually make it a point to be very clear with my clients, and I will tell them, look, I'm going to prepare this witness statement for you, and this is what I think is relevant to the case, and these are the important points that I think we need to establish your case when we go for full trial. But when you have sight of my draft witness statement, it's very important, and you should advise your client, or if you're the witness giving evidence for a particular case, then you must make sure that you tell this to your lawyers that, look, at the end of the day, you must be comfortable with whatever it is that the lawyer has stated in your witness statement, because at the end of the day, you are going to be the one who has to sign off on the witness statement, and that witness statement is going to be your sworn testimony or sworn evidence to be recorded in court. So you don't want to be a case where you just adopt whatever it is that your lawyer actually puts there, but you're not comfortable with it. You know, we've had cases at trial where you know, the counterparty just to pressure the witness, because they know that the lawyers actually prepared it, the witness statement, they ask the witness to actually read out certain paragraphs in the witness statements. And it so happens that the witness couldn't even pronounce some of the words in the witness statements. And so that was very embarrassing, you know. So then the counterparty said, was really naughty and had actually asked the witness, so who prepared this witness statement? You know, you can't even pronounce. Do you even know what this word means? Witness actually said, not really. You know, so that puts the witnesses and the lawyers in a very embarrassing situation. So you don't want to have to face that kind of situation. So whenever you put a word, so us lawyers, so those of you who are in practice or who will be in practice and who intend to do litigation, just in the first place, I think when you're drafting a witness statement, be mindful that it is going to be the witness's statement. So it should be as simple and as close to a layman terms as possible and not legalistic at all. And in any event, you should always check with the witness. I always make it a practice to ask my witnesses, are you okay with what I've said here and how I've said it here? Sometimes, and most witnesses will be very, very frank with you. They will tell you, you know, Farah, I'm not so comfortable with this. You know, it sounds so harsh, sounds so cold or something like that. Can I say this instead? And sometimes I will listen to what, and most of the time I will listen to whatever they say, and I say, okay, yeah. If I think that how they want to word their statement does not compromise or jeopardize or prejudice their case at trial, I will say, okay, let's adopt your version and we'll discard my version. Sometimes we'll do a whole negotiation. I'll be like, yeah, but if you only say that, you're not really putting across this point, and it is this point that is very important that we need to put across for your case. So can we perhaps meet, you know, in the middle? Why don't we say this? You know, so you need to do this exercise until your witness actually says, okay, I'm fine with this, I'm comfortable with this. Anybody else, I'm perfectly confident in saying that this is my witness statement. So okay, so that way you're not going to land yourself into trouble. You're not going to be put in an embarrassing position in trying to impose a witness statement that you drafted over a witness during a trial. So we've covered a bit. Okay, so preparation of witness statement, so that will encompass your examination in chief. So what is trial then? You know, what happens when you go for trial? So trial itself will usually be, you know, the entire process where first there's that examination in chief, you know, where your witness statement will be adduced in court and will be deemed as read, and the witness will then have to sign off on their witness statements before the court. So once they have signed off on the witness statement and is deemed as read, what will usually happen at trial is that it will immediately start with cross-examination. So we always have to tell your witness this, especially if you are the plaintiff, because if the witness don't know, they might think that, oh, I go to court first day, I can warm up first, and then before I have to face the other side's lawyer, but that's not the case. So usually if you are the plaintiff and your witness has to give evidence, the moment you've signed off the witness statement, cross-examination starts. And when cross-examination starts, the other side's lawyer will immediately start asking you questions, and all the questions that they will ask your witness will mostly be leading questions. I think good litigators, as far as possible, or most of the time, would never ask open-ended questions. I think one of the golden rule in doing trial or cross-examination is never ask a question that you don't really know the answer to, because then you be caught by surprise, and then you know you will then lose control of the witness or the kind of evidence that you want to solicit from the witness. So that will be the cross-examination. So after the opposing counsel has finished cross-examination, there will be what is called re-examination. So re-examination is where you will have the opportunity to re-examine your client based on the evidence that your client had given or your witness had given during cross-examination. You know, so re-examination will usually sound like, okay, just now when the counsel asked you so and so, you say yes. But remember, during cross-examination, you're not supposed to give explanation. So then during re-examination, that's when you ask, so why did you say yes? Can you explain why you say yes? So that's when the witness say, yes, I did say yes, but actually what I meant was No, most of the time the witnesses will actually take opportunity to cover whatever wrong answer that they gave during cross-examination. Say, yeah, I said yes, but it's in a different context. You know, it's not. It doesn't really mean what I said yes. What I really meant was this. So that is re-examination. Sometimes where the cross-examination has not really shattered your case. You know, like. They have had cross-examination, but so this is where, as a trial lawyer, as a litigation lawyer, you have to think on your feet and you have to make that judgment call during cross-examination. So you got to follow the line of questioning very clearly. Got to think, okay, did they manage to establish anything? Did they manage to really shake my case? If they didn't really do anything, if you don't think that, yes, they shot, they fired the shots at your witnesses, but the witness didn't really take a hit, then re-examination may not be necessary under those circumstances. Because sometimes when you do re-examination, it's worse than doing cross-examination, because your witness will then start blabbing other things that would then prejudice your case. So you have to actually make that judgment call of whether or not you really need to have re-examination for that particular witness. So once these three steps or process has actually completed. So this process will actually repeat for each witnesses. So if you have 4 witnesses, it will be, it will continue until all the 4 witnesses have actually finished giving their evidence. So once all the witnesses have given their evidence, that's when the court will then hand down some directions for submissions. So this is when we will have to put into all the things that we have that's listed here, and prepare a submissions before the court. So we refer back to our pleadings. What is our pleaded case? What was it that we wanted? And then we look at the evidence given by the witness during examination in chief or cross or re. And then this is where your case laws then come in. We have to do research. Does the evidence given by your witness support your pleaded case? Yes, no. Then we supplement that with decided cases. These days, most of the time, courts, or rather all the time, the courts will actually require parties to actually file written submissions. Some judges, they only rely on written submissions, to the frustration of a lot of litigators. Because I think sometimes when people say litigation lawyers, they think that, okay, I want to submit before the court, I want to talk, I want to be heard. But then the judge says, no, you just file written submission, I don't want oral hearing. So you then just file written submissions. But some judges, or most judges at the very least, will say, okay, you have filed your written submissions, I have read your written submissions, and then they will just tell you, okay, is there anything else that you want to add to your written submissions? Maybe you just want to highlight the important points. So it's actually very different from perhaps some of you who may still be in law school or who just finished law school, who are active in mooting. When you go for a moot competition, they give you 20 minutes, you've got that full 20 minutes to say and present whatever case that you want. But in real trial, in real cases, what actually happens is judge might just come and say, yes, I've read your 40-page or 100-page or 300 pages submission. I just want you to address the court on one point and one point only. Can you tell me that? And that's it. And beyond that, they don't want to hear you. So that could possibly happen, in submissions. And then after submissions, there will be a decision. And decision, depending or not, if you're successful, then you proceed with the last point in my practice, which is execution. So that's where, if you're the plaintiff and your claim is money, so that's where you will then proceed to execute. You either make that person a bankrupt, or you will go and garnish the monies in the bank account, and so on and so forth. So maybe we can move to the next slide, Nadia. I see I have about 5 minutes left. What time are we supposed to finish, Amelia? Because of the delay just now?
Yeah, we started at 3:15, so I think we can finish. How much more do you have?
I think about 10-15 minutes. I'll wrap it up, if that's okay.
No problem at all. Yeah.
Okay, all right. So now we look at court attendance. So what do we do when you go to court, or if you're a pupil first time going to court? Now these days, fortunately, unfortunately, depending on how you look at it, some courts, attendance will be virtual attendance, where all you have to do is really to click in and make sure you are logged in to Zoom or Skype or whatever 15 or 20 minutes before the proceeding starts. But what I have here, or what I've stated here, actually mostly is more relevant to physical attendance. So if you have to attend court, the first thing that you should do is actually to identify the location of the court, name of judge and case number, etc. beforehand. Courts are very big buildings, and most courts have high court, sessions court, magistrates court. KL court complex is very big. So if you don't know this basic information, you will be running around in circles and you will be tired by the time you reach court. Secondly, you must understand the purpose of your attendance or what exactly is going on. Are you going for a hearing, or are you going for a trial? If it's a hearing, is it a chamber hearing, or is it an open court hearing? If it's a chamber hearing, you can just wear on your jacket and will most likely be in the judge's chambers. Sometimes the judge can conduct proceedings in open court, but if the open court is declared as a chamber proceeding, so you still don't have to wear your robe. But if it's an open court hearing, then you actually have to put on a robe. So if you suddenly find yourself in court and realize that, oh, it's an open court hearing and you don't have a robe, what do? You need to then start calling SOS or go to the nearest bar room. Most courts actually have a bar room that you can actually borrow the robe for the day. Although with COVID in place, I'm not sure whether that service is still available at this juncture. Next, we're looking at punctuality. Very, very important. This is where you say early is on time is already late. So if court starts at 9, or even if the proceedings is virtual, it starts at 9, you still have to, it is always recommended to be in court or to be on standby at least 15 to 20 minutes before the court starts. So if it's physical, why you need 20 minutes? You need to come in. If if you have a hearing, you want your own space, you want to unpack your things from your bag, you want to take out your pencil case and your highlighters, you want to write your name to the interpreter, you want to find out what's the other side's name and things like that. If it's an online hearing, you want to make sure that your mic is working, your camera, your lighting, and everything is in place. So 20 minutes at the very least, you must be ready. Dress code and decorum, again, as I mentioned, you must know what purpose, whether it's in chambers or open court hearing. It's always good practice after you have finished your court attendance to prepare minutes as to what happens or transpires in court, because these very same minutes can be used for you to then update your clients as to what happened and tell the client, okay, this is what you need to do next, this is what we need to KIV, and we need to then enter all these dates into our diary so that we make sure that we don't miss out on the next date if it's a case management or hearing. So that's for the court attendance. Can we move on, Nadia? Nadia? I think she's stuck. Oh, okay. She has changed the screen, but for some reason or other, my screen is not moving. Amelia, are you seeing the same?
Yeah, I'm seeing the same thing as well.
Oh, okay.
Maybe it's just the connection.
Yeah, maybe it's just connection. It's okay. Hopefully the connection will just pick up. So the next slide basically is just basically states what kind of litigation work we do in ZRp. I practically covered this earlier when for the highlighted portions on the areas of practice that I've mentioned earlier. So we can actually move on to the next slide, which is basically things you need to know that law school doesn't really tell you about being a litigator. Okay, so this, I suppose, is quite helpful and important. I see that Nadia has actually opened it, but it's still not reflected on my screen. Emilia, you still seeing the court attendance too?
No, I see people skills must be filled.
Ah, okay.
Yeah.
So it's just me then. God, I don't know what happened. Anyway, as long as all of you can see that. So things that you need to know that law school doesn't really tell you. Okay, yes, you need people skills, because when you're a litigator, especially if you go to court, you need to deal with the interpreter, you need to deal with the clerks, you need to deal with the registry, the registrar, the opposing counsel and things like that. So it's not just you go to court, you present your case, you have your say, and that's the end of the day. So you actually have to have good people skills to be able to interact with all these people effectively. Second, you must be fit. This is actually more so for physical court attendance, because depending on what kind of practice you do, some firms would actually have a lot of matters on the same day. You know, you'll see sometimes certain firms going to court with a whole bunch of files. They may have 10 or 20 mentions in a day, 2 in this court, 3 in another court on a different floor, 2 in another court on a different wing, and then there's another one at 2 o'clock in Shah Alam, and you're in KL. So you actually really have to be fit, because you've got to literally run from one court to the other, liaise and you know, with all these people, and get all the things that you need to get done as soon as possible and on time. Which brings me to my third point, which is good time management. So good time management applies across the board, be it drafting, in advising the clients, being in court, you know, in making a call. Okay, I'm gonna cross-examine this witness. I need to move on because I can't extend the trial, or I need to be in another court after this in the afternoon. So you have to have good time management skills. Why general knowledge? I think that's always very useful. You should have very good grasp of commercial, or at least you know, latest status and you know, the affairs that are going on in the country, so that whatever you do, whatever advice that you render to your clients, especially on commercial matters, are always relevant and always up to date and you know, are commercially sound in that sense. Ability to multitask and hit the ground running, I think this is a skill that we always appreciate. You know, even though you're in your first year, the moment you know, you already have 9 months of chambering. So as far as we're concerned, the moment you're called to the bar, you know, you get your practicing certificate, we expect that you can go to court, and it's not like, I'm too scared to go for a mention. How do I speak to the registrar? I'm scared. You know, there's no time for that. You know, we'll need you to be able to multitask and already hit the ground running. Must have a lot of patience. Yes, so this is actually one of the most important things that you must have. And this relates back to what I experienced today, this morning, which caused me to be late for the webinar. So literally, I had an injunction hearing that was scheduled at 9 a.m. this morning. Because there was an injunction hearing, so I would usually wake up very early in the morning just to do my last minute prep and read over my documents. So I was up from 4 a.m. this morning, going through my papers, make sure that I remember and I don't miss out on anything. And I arrived in Shah Alam Court as early as 8:15, because you want to be early, and Shah Alam Court is, the parking is horrendous. If you arrive before 8:30, you have to climb up the hill, and it's just horrendous. So yeah, I thought that my hearing would proceed at 9. My case was at the end called at about 11:30. So you have 9, 10, 11. Yeah, so I literally had to wait for about 2.5 hours, 2.5 hours before my case was called. And we literally finished at about 2 or 2:15, and I then had to rush back to the office for this webinar. So that's why I say you have to have a lot of patience. If you don't have that patience, imagine waiting in court, sitting idle for that 2 hours. What are you going to do? You know, you can't go out and have breakfast and come back because you don't know, court might just call you, you have to be on standby. I actually know a lot of people who would actually make wonderful, wonderful litigators, but who end up either A, not practicing law at all, or B, not being a litigation lawyer and instead opting to become corporate lawyers because they can't deal with all these issues, you know, waiting, coming to court, case tak jalan, urgent, and things like that. So you actually must have a lot of patience if you want to be a litigator. Continuous learning process. Actually, this is not just specific for litigators. It applies across the board. If you want to be a lawyer, if you want to be in the legal profession, you have to always be open to continue the learning process, because the law is ever changing, ever developing, ever evolving. So you need to always learn and make sure that you are up to date on what is the latest decision, what is the latest trend in court, so that you will always stay relevant and your submissions will not be outdated. Okay, I think we can move on to the next slide, which is litigation FAQ. Okay, my screen is still not moving.
I see it.
You see it, right? Okay,
Yeah.
all right. So it's my problem. At least all of you don't have this problem. Okay, litigation of FAQ. I think these are some of the basic questions or basic issues that whether or not you are actually practicing litigation, or if you're a people, you say, I don't want to do litigation, I want to do corporate. Or it's okay, I'm just doing chambering, but after this, I want to be in-house lawyers. But I think that these are some of the basic things that you should know, so that you have at least a basic foundation and be able to answer people or questions that are posed to you. Because, you know, like it or not, our profession is such that it's like a bread and butter kind of issue. You know, even if you say you're a corporate lawyer, or even myself, I'm a corporate litigation lawyer. But the moment someone hears you, they say, oh, you're a lawyer, they will not think, oh, what kind of lawyer are you? You corporate, or you banking, or they don't think about that. They will just say, oh, you're a lawyer. Do you know my friend just had a divorce? What do I have to do? Or you know, I was just served with a writ. What do I do, you know, with this rate? You can't, it's kind of bad show if you say, oh, I'm a corporate lawyer, so I don't know what you do with it. Let me call my litigation department. Or we don't do litigation in this firm. You might want to call another firm to ask about all this kind of thing. So I think, you know, at the very least, you should know this kind of questions, or how to answer or deal with this kind of issues, so that you would at least be able to point either your clients or your prospective clients to the right direction, and to say that, yes, I'm not a litigation lawyer, but you receive a rate. Again, like I said, you have to be able to solicit, and once you have solicited the proper or the correct information, then you can direct them, you know. So if you say, okay, I just got a rate, what do I do now? So first question, what do you then do? So you usually ask, when did you receive the rate? So that would be the first important question. Okay, then they will say, I don't know, it was just in my post box, I don't even know when I received it. You know, sometimes you'll say, okay, is there an AR card? Did you sign off on it? Did someone else sign off on it? Because the date of receipt of the rate is very important, because it will then determine when you need to file your appearance in court. Because if you're already out of time to file your appearance in court, by the time you know of this existence of the rate, a judgment in default may have already been entered against you. So this is the kind of questions that you want to ask the client. Okay, you've received this. When did you receive it? Okay, you received it yesterday. Okay, you still have time. You have about at least 10 to 13 more days to appoint a lawyer and to get a lawyer to advise you. But if say you received it 2 weeks ago and tomorrow is the last date to file an appearance, then maybe my advice will be, oh, okay, no time for you to get your advice, just get a lawyer to file appearance first, so that a judgment in default will not be entered against you. Once you file the appearance, then you have 14 more days to file your defense. Then you can think about, you know, what defense you want to file, or what you need to do moving forward, and things like that during that time. So you should know all these important facts. So insofar as the timeline for filing appearance, it's 14 days from the date of receipt of the writ. I think that's very important for everyone to know, not just litigation lawyers, but across the board. What does without prejudice mean? You know, a lot of us always see a lot of correspondence that says up there, without prejudice. You know, what does that mean? Do I want to use without prejudice? If I say without prejudice, does it mean it's really without prejudice? Now, this is actually an entire chapter on its own. But basically, without prejudice means that when you issue a letter, you don't really want the other side to be able to refer to that letter against you. So again, you have to think, yeah. So if you're actually issuing a letter of demand where you are telling the other side, look, you have not done this, you have not done that, so I'm saying that you are in breach of your obligations. Now, surely these letters you do not want to mark as without prejudice, but you'd be surprised at the number of people, or the number of organizations that sometimes use this without prejudice term indiscriminately and end up actually marking documents that should not be marked as without prejudice as without prejudice. So I think that's one of the important things that we should know, either you're a corporate or litigation lawyer. What is a judgment in default? As I've mentioned earlier, if you do not enter appearance within the stipulated time, which is 14 days from the date on which you are served, a judgment in default will be entered against you, meaning that the court will just consider, okay, you didn't apply for it, so I'm going to give judgment for the other side, meaning that they will get basically whatever they want, unless you apply to set aside the judgment in default. So again, this is very important. So some client, they might tell you about the rate. They say, I don't know about rate. I didn't receive any rate. I didn't receive any letter of demand, but I got this. It says judgment in default of appearance. So what do I do? So again, same question. When did you receive this judgment? You look at the date of the judgment. So judgment say 1st of January, number one. Second, when did you receive the judgment? Oh, but you only received it on the 1st of February. So the law then says that you have 30 days from the date on which you receive the judgment to actually apply to set aside the judgment in default. So that's where all these things would actually come into play, and you will know whether you need to move expeditiously or not. Okay. What is the letter of demand? I've already covered it. It's usually a letter that says, no, this is what I want and I want to demand and you have to comply. What is the statutory demand? This is a wide term, but normally in commercial transactions, when you refer to a statutory demand, the most common statutory demand that you will see is a demand for under Section 466 of the Companies Act, which is basically a demand for an amount due and owing. And if you fail to comply with that demand, then the other side can then commence winding up proceedings against you, as you will then be deemed to be insolvent or unable to pay your debts for failure to actually reply to a statutory demand. How long do legal proceedings normally take? Wow, this is a golden question. I think courts in general these days at the high court level, they do have KPIs, unofficial KPIs for that matter. So I believe that high court judges or first instance court will usually try to dispose of their cases within 9 months to about 1.5 years from the date of filing. So if you file your case in January this year, you can expect in normal circumstances, in normal timing, that it will finish by perhaps at the latest mid of next year. But however, as we all know, with COVID, there was a backlog of case because courts could not really operate for a couple of months, and physical attendance is a bit restricted. So unfortunately, the courts these days have a bit of a backlog. So that timing or time period is unfortunately extended and will likely be extended until the court has managed to actually clear off their backlog. Do I have to go to court to claim monies from someone? This depends, because sometimes, well, when you want to make a demand, sometimes you make a demand, you write a letter, you demand from the other side. Best case, the other scenario, the other side will reply and say, okay, here's your money. I'm not going to contest. Sometimes they jual mahal a bit, they will say, no, I don't want this. But after two, three letters, they give up and they say, okay, here's your money. So settle, you get your money so you don't have to go to court. But sometimes they'll be, nope, not paying you, see you in court, and you have to go to court under those circumstances. So I think these are the normal litigation FAQs. Next slide, Nadia. Okay, questions, Q&A. Excellent. Do we have any questions?
We do. Okay, I'm just gonna share my screen. Okay. Okay.
Wow.
Yes.
Okay,
I think the first question, I think I'll save it for last, the juicy bit. Okay, number one, is it possible to be presented with a document not exchanged before during the course of trial? If yes, what do we do then?
Yes, it's very possible. In fact, it happens almost all the time. So what do we do with them? Usually, okay, again, it goes like on TV. Where you see on a drama, say suddenly the other side will say, here, I have this document that does not say what you want to say. Now, in real life, courts will not be very happy if you come up with those kind of surprise on the actual day of trial. So you can't not disclose a document during the pre-trial stage and then later on do that. So if you receive a document at the last minute, what we usually do is we look at the documents and we'll see whether or not it is something that is really material, sometimes it's a last minute document, but it's non-contentious. It's just a formality kind of document. So I would normally not object to those kind of documents. At the end of the day, you must remember that we are all members of the bar. Okay, so don't treat your opponent like your enemy. Today they might be your opponent in a case. Tomorrow they might be your co-defendant or co-plaintiff and things like that. So if it's something that does not prejudice your client and it's not something that is materially changes your case and you don't really have to object to it, then I would say don't object to it. Just let it slide. But sometimes there are circumstances where I don't object to it, other side don't object to it, but the judge is a stickler for all these timelines of propriety, and the judge said, nope, I am not allowing this document. Too bad for you. Who asked you not to produce this? Who asked you not to prepare your case beforehand? So that can actually happen. But if the document is material, usually what we do is we'll object. We'll tell the court, look, my lord or my lady, this is a material document. It was not disclosed to us before. We need to take instructions on it. And what we'll usually tell the court is that if the court is going to allow production of this document or the other side to refer to this document, then we will seek an adjournment of the trial so that we can go back and ask our clients about this document. But if the court if a court does not want to adjourn, then don't allow this document. So that's usually what we do. In most cases where the document is very material to the other side and you have a good excuse of why they can't get the documents before trial, during pre-trial case management case, the judge will likely say, okay, you can refer to this document. I will adjourn the trial. Farah, you can get cost of the day because you've prepared and you are ready to proceed for trial today. So cost of the day can range between 500 or 1,000 or 2,000 just because you've gone to court that day. So for those of you who may think that, oh, I want to keep this court and just bring a surprise on the other side during the trial itself. So just be wary that the judge might impose either one, the judge might not allow you to refer to that document altogether, or at the very least might allow you to refer to the document, but impose a cost against you under the circumstances. So I hope I answered that question. Okay. Next, how are settlement discussions usually conducted, whether oral or written, and is it made between the parties or can it be done through their representatives? It can be both, actually. Sometimes when parties are still on amicable terms, we usually, or even when they're not on amicable terms, but it's so straightforward, we can just write a letter to the other side, say, here, this is what I have to offer, or this is what I'm willing to do. Are you okay with this? And the other side will say, yeah, okay, we're fine with this. Sometimes it's a bit, the intricacy of the matter, it's a bit more complex, a lot more structure or corporate considerations have to be put in place. So you actually have to have a meeting. So then you have a meeting like oral and then followed by written proposals and things like that. Sometimes parties are just so over with each other. They literally don't want to see the face of the other side. They will just tell the lawyers, you go speak to the other lawyer. I don't want to see them at all. So it is a combination of both, actually. Next, how does a litigator handle a client with wildly unrealistic expectation? Okay, I think this is actually a very interesting and wide. I mean, what do you mean by wildly unrealistic expectations? I have clients who will always tell me, Farah, I have this great case, confirm if I give you the documents, we're going to win, we have a good case against them, they didn't do this, they didn't do that and whatnot. And then they give me the documents, I look at the documents and I'm like, yeah, they didn't do A to E, but you didn't do F to Z. So, not that great case for you. Okay, so you need to balance that expectation to the client, and by basically telling them, okay, look, this is your you don't want to tell the client that they have a completely bad case, or at least if they come to you, you can't say that, okay, it's completely hopeless. So usually you have to sort of do a tai chi. You have to align and redirect them. First, you can say, yes, they have breached. Yes, they may appear to have done this and done that. However, that's when you realign and Tai Chi and read that, right? However, there is always this clause in this thing, and it would appear that you have also not done this. So do you really want to be that harsh against them, or can we meet each other in the middle? Or because of this, once you have a good case against them, you can actually file a claim against them and probably win for this 500,000 that you're going to claim against them. They would most likely file a counterclaim against you for 600,000, which will mean that you will end up having to pay an additional 100,000. So then you say, since they haven't filed a claim for the 600,000, do you even want to claim for your 500,000? Because if you're quiet, they don't claim, you don't claim, you save that 100,000 technically. So this is the kind of like commercial kind of knowledge that you must know and be able to advise your client. And then, as I mentioned, like if you want to deal with their expectations, client usually thinks that they have a good case, because when they come to you, they're upset, they think the other side is in the wrong and they're in the right. So you gotta, you have to learn to manage the situation and their expectation by basically saying that, yes, this is it, but this is how we should do it, and this is the right way, and this is perhaps what you can do. If it's not too late for the clients yet, then to advise, okay, to mitigate the situation, maybe you need to do A, B, C, and D, and then we can see how it goes from there. Okay, I hope that answers the question.
And next is, what is the weightage of a criminal judgment in the civil court if the opponent tendered criminal judgment as an evidence in the civil suit?
I think it will boil down to the relevancy issue in the first place, whether or not that criminal judgment is actually relevant to the civil proceedings. Because, for instance, if it's a, say, defamation case, and you have said that someone is a crook, is a cheater, is a liar, and things like that, and a police report is lodged against that person, and the criminal court has held that this person has in fact cheated, and the person has then been sentenced to jail, then of course that fact that that person has been sentenced and found guilty in criminal court would help you in your defense of justification, in the sense that, no, I'm perfectly justified in saying he's a crook and he's a cheater, because clearly he has been found guilty by and doing all those things by the criminal court, so I'm justified. So I would say it will boil down to the issue of relevancy of that criminal judgment in the first place.
Okay. How does a litigator handle a client with wildly unrealistic expectations?
Oh, I dealt with this just now. The Tai Chi, aligned and redirect.
Okay. How many hours you work during your first year of practicing, and what would be your advice to a student who is interested in litigation? Any tips?
How many hours? Oh my God. In my
Difficult
first
question.
year, I think in my first year it's definitely more than 10-15 hours a day, simply because we're just starting out, and the learning curve was actually very, very steep. I think practice sometimes is very different for different people. It depends on what firm you joined, what kind of work you do. Some people start off in their first year a bit relaxed, because they join a firm that mostly does advisory and clients are not too pushy and things like that. But some people start out their first year into the battleground. If you go to a big firm and they do a lot of contentious matter, you find yourself having to put in a lot of hours throughout the week, or spend weekends, Saturdays and Sundays. So I used to work, I think suffice to say, I used to work very long hours in my first year. Most of the time I would actually have to stay back on every day, and I will usually, because those days, unfortunately, my time was not so mobile as this time. It's just about 10 years ago. Not that old, okay? But even back in those days, we can't really access some of our documents online and things like that. So we have no choice but to come into the office over the weekend just to go and pour through all the documents in preparation for the trial. So I would say very, very long hours.
Okay. Have you ever experienced worse situation as a litigator? If yes, can you share with us how you handled it?
Worst situation as a litigator? Wow. No, I think that as a litigator, because you're dealing with dispute and problem, it's always like a drama on a daily basis. So, and then the thing about us is that you need to also move on. So one of the things that I will always advise all litigators or all lawyers for that matter is don't get too invested into your file. You know, it's at the end of the day, it's work. So you need to draw the line and move on to the next thing and things like that. So the single worst thing, I can't even remember. I am pretty sure I have, people around me, if some of you have, I see my colleagues here or my team members here. If you remember me telling any of you at any juncture that this is the worst day of my life or it's the worst case I've ever handled, and then please remind me, because I tend to have very convenient memory and I tend to forget all these things to move on. But suffice to say that there's a lot of very, very bad experience that if I were to list down, it's going to be a whole session altogether. But how I handle it is as what I mentioned. You need to treat it as work. It's just like exam questions. You have 10 questions. You have 10 questions and you just know that you need to finish it within the next hour. So you need to move on to the next question, within a certain time. But otherwise, sometimes, yeah, I would say a lot, but there are good days and bad days. I think if you say worst days, those days that when you win a case will definitely be the wonderful days, or the days where your client is very happy with whatever you do, even though you lose a trial, or even though you lose a case, client says, yes, you've done your best. Unfortunately, yeah, court's not in our favor. So I would say those are good days.
Okay, I think we just have 2 more questions. Based on my experience during pre-trial, some judges didn't set the date for both counsels to file witness statement. If this happens, is it proper for me to ask?
I would say yes, actually, but it depends on which side you're on now. Because if you are the plaintiff, because you have to start your case, right? And if you're very busy and you don't really have much time to prepare for your case, then it's good not to have a deadline so that you can literally just file your witness statement either the day before or on the day of the trial, and it's okay because no deadline was actually fixed. But if you are the defendant, then you actually have to start on the very first day of trial cross-examining the witness for the plaintiff. So under those circumstances, then obviously you would want to look at the witness statement so that you can prepare your cross-examination questions better. So under those circumstances, it would benefit you to actually have an earlier deadline so that you can have sight of all the plaintiff's witness statements and prepare for your cross-examination. So I hope that answers your question.
Okay, the last juiciest question. What is the most interesting case you've dealt with throughout your career?
Okay, most interesting case you've dealt with throughout your career. To be honest, it might sound a bit unbelievable, but I literally I can say that I'm the kind of person who likes to try and find an interesting point in every case that I do. So even if the case is actually very boring, number one, I will try to say, okay, what's interesting? Let's try to make this juicy. Because this is your work. You got to try to find a joy in doing whatever you do. Because if you don't try to find the joy, after a while you see all the claims, it looks like it's all the same. Everything is debt recovery. Then you won't see the interesting point that is embedded into each of that. So so generally I enjoy my cases. Most interesting, I suppose, can be associated to most high profile or cases that some of the landmark cases that have actually garnered public attention. So I think some of those cases are like the case involving the Perak constitutional crisis, the Menteri Besar crisis. So I think that was the first time that I was actually involved in a not the first time we were involved in a so-called public interest kind of litigation, but it was the first time that we did a case that had garnered so much media attention. I remember the day that, because it went straight to the federal court. So we were in the High Court, Court of Appeal, and federal court in less than 6 months, because that case moved very fast. So at the High Court, I remember we lost at the High Court. So I remember after losing in the High Court, as we were going to take the decision, so every time we go to court, there will be swarming of reporters. You know, those of you who are in practice, you know, you see those reporters covering Najib's case. So it was something like that. You know, I remember there was one point where we were taking a lift, and the moment the lift opened, I felt like Britney Spears. Although my pictures never came out, but I don't know what was it that they were clicking. So I think that has got to be one of the most interesting cases in a sense. So that's on that publicity or attention and public interest kind of issue. But on the issue itself, I thought it was very interesting because we were dealing with the issue on the discretion of the sultans, the royal prerogative of the sultan in deciding whether or not to call for state elections at that juncture when one of the Menteri Besar has basically lost the majority of the Dewan. And I think that is actually a very relevant issue, because I think after the Perak Menteri Besar case, you see a lot of these issues coming into place, because before that, if one party has lost the majority, it almost goes without saying that elections will be held or by-elections will be held. But ever since that case, that basically established that the Perak Sultan or the Yang di-Pertuan Agong in the context of the federal government actually has the power or the royal prerogative to decide on whether or not to see who commands the majority of the support in the Dewan Rakyat or in the State Legislative Assembly. So I think that will be one of the most interesting cases that I've dealt with.
Okay, I think that was very, very interesting, very insightful. And I think we've reached the end of the webinar already. Thank you, Ms. Farah, for the extensive explanation, your tips and your experience. It was very, very great. Thank you everyone for joining. Hopefully you also join our other webinar sessions upcoming. Please follow our LinkedIn and our Instagram for the latest updates.
Thank you all. Bye. Good evening.